given you a chance to refresh and to fuel up and get ready for the second session of today, which of course is going to be dominated by multiple plenary sessions. So if you didn't have an opportunity to weigh in or give feedback in the way that you would have liked to, the afternoon plenaries are really going to be able to give you a chance to do that. With that said, Dr. Mshai, please switch on. Yes, there we go. Please switch on your camera so we can see you. Dr. Mshai Mongola. Pleasure to actually see you again. This time it's not in person. Looking forward to when we can have the conference and all of us be together again. So I am going to be leaving you in the very capable hands of Dr. Mongola, who's going to be running the afternoon session for you. Dr. Mshai, it's over to you. And thank you all to the delegates and to all of the panelists for this morning. A quick announcement before we go. I had actually forgotten to mention this. They will be putting up the recordings of the session on the website on Friday. So if you have missed something, it should be available to you from Friday. Dr. Mshai, it's over to you.
Thank you very much, Kathy. And can I just thank you on behalf of all the participants? You have been such a wonderful moderator. I have thoroughly enjoyed not only the fascinating conversations we've had already, but also just the expert and wonderful way you have held the space for us. So thank you, Kathy. It's always a joy to catch up with you, and I look forward for us being able to, again, have a conversation when we see each other face to face. And I hope you will stay around.
Yes, I will just be at the bottom of the room.
I look forward to seeing you now engage as a participant. And thank you for that, telling us about the recordings. I'm already getting some inquiries from people who are following on social media. And so I just want to start by thanking everybody who has done any kind of contribution, because this has truly been a fascinating conversation. And we have had such rich insights already as we ask ourselves, with regard to customary law, culture, and social justice, if transformative constitutionalism has truly advanced equality and other human rights in customary law. Let me thank Professor Mandosela and the team for just putting such a rich banquet before us, and for the privilege of being in this space. As she pointed out this morning, Kenya and South Africa have had histories of commonalities, and not the least of which they both have, in relative terms, fairly young constitutions. As we were reminded this morning, that these constitutions on the chart, Kenya certainly has benefited from the insights of the South African Constitution. And so I hope that the case study that we'll be looking at as we look at what lessons we have for each other will be useful to all of you, as useful certainly as those of us who have been listening in from the rest of the continent, and I'm sure the world, have found the discussions this morning that focused on South Africa. Let me just set up again the panel we are going to have by just saying that in Kenya, we have an article of the Constitution, Article 11, that states that culture is the foundation of the nation. And there's been a lot of discourse on this, perhaps not as much as there should be. In one of the drafts of the Constitution that we had, indeed, people of Kenya had demanded a fifth chapter on culture, which questions that we are now finding ourselves discussing in relation to customary law. So it is really a great opportunity for those of us joining you to think together with you on the place of customary law in relation to social justice. So I know that my distinguished panel thanks everybody for the opportunity to speak out and think on this. And so to help us think about the question that we are looking at in particular, which is what good practices exist on transformative constitutionalism, advancing equality under customary law, I am joined by a keynote speaker, Justice Mumbi Ngugi, and then we will have two interventions from Abubakar Zaid and Kinali Mwika, which will then open up for a plenary discussion. And I'm going to encourage you to please put your questions in the chat, just as Kathy had asked in the morning, so that as we proceed, we will be able to start to prepare the conversation. I know we have very tight time. So we have 10 minutes each. And I'm going to ask my keynote speaker, please, as I introduce her, if she could please just put on her camera. Let me invite her to do that so that we would be able then to engage. So our keynote speaker is Justice Mumbi Ngugi. Justice Ngugi is a judge of the Court of Appeal of Kenya, having previously served as presiding judge of the Anti-Corruption and Economic Crimes Division of the High Court in Nairobi. She has, for the last 9 years, been involved in the emerging human rights jurisprudence in Kenya. And with regard to this conference in particular, she has contributed a lot in relation to the socio-economic rights guaranteed in the Constitution of Kenya 2010. Indeed, Justice Ngugi is a long-term advocate of human rights in Kenya, having been involved in advocacy work for the rights of women and children, which we have touched on extensively in the morning, as well as the housing rights of the urban poor. She has also been a prominent activist for the rights of persons with albinism in Kenya. And I know we haven't mentioned very much about this in the morning sessions, but I did want to note. Perhaps I could request if everybody else their mic. That would be very much appreciated. Get the echo. Maybe I could also request it to make sure that everybody else makes sure. Colleague Radebe, if perhaps you could show your microphone. Thank you very, very much. And let me just repeat that I wanted to note this in particular because I think we might also want to bring the question of customary law and social justice in relation to people with disabilities into the conversation. Justice Mumbi is a recipient of several awards, including the International Community of Jurists Kenya's Jurist of the Year Award. And I'm not going to read all of them, but she was honored and she has been honored in 2021 as the Global Jurist of the Year by the Center for International Human Rights of Northwestern University's Pritzker School of Law. And I mention this because I know that some of the reflections she's bringing to us are not just from the Kenyan space, but really from the wider space. And finally, let me also mention that Justice Ngugi chairs the African Regional Judges Forum on Judicial Education. So I do hope that some of the insights from this conference will enrich the conference there. Justice Mumbi Ngugi, welcome.
Thank you very much, Moshai and Naimshai, and nice to see you again. Can I be heard?
Yes, you can. Thank you very much.
All right. Thank you very much. And thank you for that very glowing introduction. Now, I've got to say that I've got a bit of difficulty because of the time limitation, which I noted was also a challenge in the morning, but I'll see what I can do with the limited time that I have. And I think I'll go straight to considering how we in Kenya have addressed the question of customary law and culture, both in the constitution, in legislation, and in jurisprudence from our courts with a view to advancing social justice, but specifically in relation to women. Maybe perhaps at another time, when time allows, we can delve a little deeper into the question, including the questions of social justice for persons with disabilities, as Dr. Shai has mentioned. So we have a constitution that is very similar to the one of South Africa, and I think we have borrowed a lot from them, both in terms of the constitution and in relation to jurisprudence. We promulgated our constitution in 2010, and which has been described by many as a transformative constitution. I think the critical facets of this constitution is that it has a major commitment to transforming our society. And we have, in that constitution, made one of the underlying core principles the question of social justice. But as Mushai mentioned, we have also at Article 11 recognized the important place of culture as the foundation and the foundation of the nation and as a cumulative civilization of the Kenyan people. Now, when we consider social justice in the context of customary law, we cannot therefore divorce it from culture and all that it pertains. And we know that culture relates to the ideas, the customs, and the social behavior of a particular people or society. Our customary laws consist of the laws and practices of each of our respective groups. We have made customary law, like all other laws in Kenya, subject to the Constitution, and under Article 2.4 of the Constitution, which is, I think, similar to what you have in South Africa, any law or custom that is inconsistent with the Constitution is void to the extent of that inconsistency. And we have also in legislation, in our case, we have the Judicature Act, which predated the Constitution and is actually a colonial product. We have recognized customary law as a valid source of law. But, and I think this came up in the morning, we subjected under the colonial regime to our customary laws to the test of repugnancy. It is only applicable to the extent that it is not repugnant to justice and morality or inconsistent with any written law.
Justice Mumbi, if I may just interrupt, could you just move your camera slightly because we are not seeing, we're only seeing the top part of your
you're
head.
only seeing the top of my head. Let me see what I can do about it. I'm sorry about that.
Just move your...
Is that better?
Yes, thank you very much.
Okay, I'm sorry about that. Let me go back to the presentation that I also have on my laptop. I think that might be part of the problem. Like you mentioned questions of albinism and disability, I tend to put a large font to be able to present properly. So I hope you excuse me for that.
That's absolutely fine.
So yes, so I was saying that culture and customary law are important sources of law in Kenya, and we have given them constitutional and legislative protection. However, I think in Kenya and elsewhere, we recognize that culture and customary laws can be and often run counter to the fundamental rights which are enacted and protected in the Constitution. So while in Article 11, we recognize and protect culture, we have also talked about social justice in Article 10 as one of the core values in our Constitution. And we have also in Chapter 4 set out a whole gamut of rights that people are entitled to. Many of our customary laws and practices, many of our communities, equality, non-discrimination are not principles that are respected. The many of our customary laws and practices, we have a major preference to the male child. We have a persistent belief in the inferiority of women and the superiority of men. Many of our communities, and this I think came up in the morning, we have an infantilization of women. In some of our communities, if you visit, they will tell you they are only children at home when they're making reference to women and their children. And because of these women, we deny women access to economic resources, predominantly land, which is a major resource. We have customary laws and practices that discriminate against women in matters of inheritance and within the question of marriage. So it's not surprising then that here in Kenya, and I think in many other places, we find that the denial of social justice for women and the discrimination against them is most significant in the areas of marriage and divorce, the division of property, the inheritance, and the care and custody of children. But we also have other practices which are harmful. They are cultural practices that are recognized in our customs, which are harmful and which have a major bearing in access to social justice for women. And these are the practices that we might, we need to mention. And if I had sufficient time, I would get into them in some depth. In relation to this, in particular, is a question of widow inheritance, harmful practice, cultural practices like FGM, the question of return of dowries, on the dissolution of marriage, and of course, the question of child marriages, which deny girl children as young as 13 years access to education and marry them off to often older men, which again denies them the opportunity to achieve what they can, which they're guaranteed to the Constitution, as in order for them to achieve the same opportunities, get the same benefits as men in relation to the human rights that they are guaranteed in the Constitution. But I think I'd like to speak in the time that I have a little more about the question of land in inheritance. We know that we have noted that in our context, while the Constitution prohibits discrimination and provides for equal access to land and property, in practice, women still remain totally disadvantaged and discriminated against. In our context, I think about women comprise about 80% of the agricultural labor force. They provide about 6% of the farm income, but only 5% of land titles are registered jointly in the names of men and women, or women in the space, but only 1% of land titles in Kenya are registered in the names of women. This underrepresentation in land ownership, I think, is a feature of the customary law and practices which deny women the right to inherit land and other forms of property. We'll note that in most cases, women have only secondary rights to land through their relationships to either their fathers or their husbands. Now, this exclusion of women from land ownership is manifested in both legislation and jurisprudence. And I want to which demonstrate how in the past our courts have looked at the rights of women to inherit on an equal basis with men, which, like I mentioned, has an impact on their capacity to have adequate economics that they would be entitled to. And one of these famous cases was the case of Mary Rono and Jane Rono. It's a case that predated the Constitution. They say that women, or rather daughters of the deceased who were pitted against their brothers in the court, were entitled only to a very small percentage of their father's estate on the basis that they would marry, they were likely to get married, they would inherit property from their new families, and they were therefore not entitled to the same ownership of property as their brothers. Now, the court in this case, in reviewing the High Court decision, it held that children of a deceased person are equal regardless of their gender, and to hold otherwise was discriminatory against women. You know that it applied, the court in that case applied the Convention on the Elimination of All Forms of Discrimination Against Women, which contains the equality principles that are now contained in our Constitution. Subsequent decisions have now followed that decision in Rono, and I could cite a few more, but I will not do that in the interest of time. But basically, the court is saying that in applying our succession laws of inheritance, we cannot discriminate against women. The law should enshrine the principles of equality of distribution of property between men and women, because men and women are equal and they are entitled to the same rights, the same benefits in relation to inheritance. We have a similar challenge in matters of marriage and divorce, where in many of our communities, when women were divorced, as one writer once put it, the women would only be entitled to the pots and pans. Their work was in the kitchen, they were not entitled to any more than that. We now have Article 45 of our Constitution, which says women and men are equal at the conception, at the start of a marriage and during its pendency and at its dissolution. The problem comes that while we have those clear provisions, the interpretation in our law, the legislation that has been put in place to deal with that constitutional provision is that in a vulnerable state, because it talks about contribution, and women must show contribution at the dissolution of a marriage. And the contribution that they must show is financial contribution. So the question arises, given the respective roles of men and women within a marriage, where men may be out there earning money and women's traditionally and our culture have to stay at home and look after children. How are we to value the financial contribution of women whose contribution is not in monetary terms? So that question still needs to be resolved properly. There are courts which say we can give women 50-50, others want to give a lesser percentage because of the court's respective perceptions of what amounts to proper contribution in relation to property acquired during marriage. I want to touch briefly on questions related to community, to land, access to community land. This again came up in the morning, but I want to address it specifically in relation to community land in communities where there's still a lot of land held communally. And how it will be determined is a petition pending before the High Court that addresses the question of women entitlement to participate in adjudication of land in group ranches. Among the Maasai, a lot of land is held communally. It has been registered in group ranches. A lot of the time, women portion of that land into individual or group titles, because under the customs of that community, women didn't own land, didn't have a right to participate in the ownership of land. And in that case, the court said it has a right to look at the question whether it is proper for customary laws to exclude women in the adjudication of community land, where just on the basis that they are women and that they are also unmarried. So the question of gender and marital status, the limitation to the rights of women to equal treatment under customary law is a question that may be addressed, I think, in the foreseeable future in our country. I don't know how I'm doing. I suspect I'm doing badly on time, Mshai, but you can let me know. What I find...
Wind up? To start to
yes,
wind up?
I think I will just try and wind up and just speak briefly about what we find. So we have a constitution, a constitution that can be transformative in helping to achieve social justice for women. But to do that, I think we need to recognize that first, culture and customary laws are dynamic. In many respects, our culture and our customary laws have changed significantly. In many respects, our culture and customary laws are inimical, I think, social justice, so far as participation of women in all spheres of life is concerned. So we have to find a way, and in time, I believe we will be able to do that through jurisprudence and accept and support those elements of customary law and culture that are conducive to the enjoyment of equal rights and access to social justice for all people in society, but to find a way of discarding and disregarding those elements of custom and culture that are really inimical to social justice. The question of going back to our customs and culture arose in the morning. I think for me, the answer is we have great difficulties in going back. It is not a possibility. What we have to do is pass legislation, determine cases in a manner that advances social justice while maintaining those elements of our culture, our customs that are in accord with the constitutions and the constitutional principles that we have established in our 2010 Constitution. I will, I think, leave it there if it is all right. And I do apologize for exceeding the time a little bit.
Thank you so much, Justice Mumbi. You have indeed taken us and fleshed out and continued. I'm really happy to see how we are all in one big conversation. And you've really challenged us that we must find this way of recognizing and supporting elements of customary law that advance social justice while being aware that not all of them do. So
yes,
just again, let me remind everybody who is not speaking, please, if you do not mind muting your mic so that we could be able to hear from the speakers without any interruption. And I also encourage us to start to put our responses, our questions, our comments in the chat, and we'll take all of them as we then come to the plenary discussion after we hear from our two panelists, both of whom will speak for 10 minutes. And I will start by introducing the first one. Abubakar Zain Abubakar has been and was a member of the People's Commission of Kenya and then the Constitution of Kenya Review Commission, both of whom were very critical and very foundational to the constitution that we have now. He served in particular on the Technical Working Committee on Culture that reflected on many of the issues that we are discussing today. Abubakar has also served as a member of the East African Legislative Assembly, where he chaired the Regional Affairs and Conflict Resolution Committee. So some of the discussions on land, I think, might be of interest over here, and has also served in civil society, leading organizations such as Uraia Trust, Muhuri, and the Oricha Collective. Abubakar Zain, welcome.
Thank you very much, Dr. Mshai. In the interest of time, I'll just say thank you for everyone who is participating, and thank you, Honorable Justice Mumbi Ngugi, for giving us a perspective that I totally agree with. So I will endeavor not to repeat anything that Justice Ngugi has made reference to, save to say the following. In relation to the transformative nature of the Kenyan Constitution and the similarities that it has with the South Africans, we also have differences. One of the major differences that we have between the Kenyan Constitution and the South African one is that the Kenyan Constitution, although we provided for aspects of culture and customary law in various parts of the Constitution, in its final negotiations for enactment, the institutional framework for the implementation of those cultural and the customary law provisions was taken out. So for instance, one of the design and architecture of the Kenyan Constitution is that on every substantive chapter, there is an institutional framework for its implementation, except with in regard to the constitutional provisions that touch on culture and customary law, with the exception, of course, of the Muslim law, which has caveats. So in relation to the components that I would like to focus on, that because we are lacking of that institutional framework, for example, in South Africa, we have a chamber of leaders, community and cultural leaders who can negotiate and discuss some of these important issues. In Kenya, we don't have that. So one of the challenges that we have is that we need to, through legislation, develop an institutional framework for its implementation. The second point I wanted to make is that although we normally focus when we talk about culture and customary law, we tend to mainly focus on personal law, and particularly in relation to marriage and divorce and inheritance. There are very many other aspects of culture and customary law that would be very important in transforming our societies. Some of them were touched by Justice Ngugi. On the question of land, for example, and natural resources, there are very many transformative ideas from our culture in terms of environmental protection. And this normally would not be part of the discussion. So that when we talk about, for example, the issue of environmental justice and how to save our planet, we are charged short by not understanding and tapping into wisdom that has been developed by various communities. So one of the transformative areas I believe that we can also focus on is environmental protection and creating harmony between communities and the environments that they live in. But let me go to another point because of the limitations of time. And for me, this is also in relation to peace, how to establish peace in societies and how to reconcile peoples. And we have provided, for example, for alternative means of dispute resolution. And among some we have indicated in Article 159 of our Constitution is traditional means of conflict resolution. Now, I know Justice Ngugi has talked about the very many limitations and some of the things that we need to reform or completely outlaw, which are already outlawed by our constitutional framework, but in practice, there are many challenges. Again, there is a lot of good ideas, wisdom, and practices in terms of alternative means of conflict resolution, including reconciliation. The area of peace is very critical in our societies. If you look at Africa as a continent and the world over, peace is a big challenge to us. Let me make three more points and then stop. One is that listening from morning, I agree with those who speak and say there's great tension between the colonial component on law that has been with us and community aspirations and community based on culture, of which partly form the resistance against colonialism. And that resistance has also created a lot more tensions between us. So what needs to happen with that is that we need to have a deconstruction process that deconstructs both the common law, and it has a number of very many negative things, and also deconstruct customary law and culture to tap into the positive things that support social justice and discard those which undermines the dignity of human beings, and particularly those who are discriminated, women, children, persons with disabilities, and so on. But also, the second thing I think I need to say is that in order for us to tap into these transformative aspects of culture and of customary law, we need to do a lot of research. And this is something that is missing in the conversation, that research is so critical, both in terms of identifying those uplifting and upholding of human dignity components of culture and customary law, but also identifying those which needs to be repealed, needs to be reformed, and so on. And then last but not least, two things. One, in the morning, you had a number of references to the process of codification of customary law. And one of the challenge, at least in Kenya, is that at the last count, we have more than 100 plus communities. And all these communities have unique cultures and also have unique customary law. So research would be an important component that allows us not only to identify, but also to start the process towards codification, which has very many contentions. Therefore, I promote the idea of research. And then lastly, I think that there is also a demeaning attitude of those who have just been oriented in the common law, that tends to think of culture and customary law only in negative perspectives. So I think it calls for us to have a balanced view, which is also based on evidence. But I think we have started this process, even providing, for example, for recognition of Kenyan languages in the Constitution is a revolutionary act. I hope that we will be able to create harmony and reap the benefits of uplifting the dignity of human beings and also outlawing those which discriminate, but don't throw the baby with the bathwater. Thank you very much.
Thank you very much, Abubakar Zain. And I'm going to go straight to our second panelist, Kanyali Mwikia, who is the Equality Now Africa Office Program Officer for Legal Equality. And in this role, Kanyali coordinates the organization's work to ensure the promotion and protection of the rights of women and girls in Africa. So I'm particularly happy that he's on this panel, especially given the extensive experience in equality law, international cooperation on human rights, and socioeconomic rights in Africa that Kanyali brings to the table, as well as the many initiatives increasing women's representation, in particular, promoting LGBTQI rights in international and regional human rights forums, and raising awareness on the role of ethnocentrism in the political system. I highlight that because we've talked a lot about ethnic communities and tribes and their rights in terms of the conversations we've had so far. So Kanyali, over to you. Kanyali, let me ask you to, I'm not seeing your camera. I don't know if, okay, was there?
Hi, Dr. Mwangola. I'm so sorry about that. I don't know if you guys could hear me, but my internet is not the best. I don't know what's going on, but.
Okay, we cannot see you, but I was hearing you. I don't know if you just dropped off. And maybe if I remind everybody else to please mute your mics. Kanyali, can you hear me, please? Okay, I think we.
Hi, Dr. Mwangola. So sorry about that. I think I'm just going through internet.
You're fine now. You're fine now. Go ahead.
I thank you so much for that introduction, and thank you to my previous co-panelists with a specific mention to Abubakar Zain and Justice Mumbi Ngugi, whose work I really admire and follow as a lawyer. And I'm just going to jump right into it. I had a very small presentation that I wanted to share, which kind of like would traverse a lot of the things that I wanted to talk about today, especially in terms of like, how the Constitution of Kenya has dealt with legal plurality, or what we call legal pluralism. And as things happen, like I had a very good thing going, and, like I had planned everything out, and then my internet gave out, but I'm so thankful to be here. And the first thing that I wanted to talk about, I think most of us know about like what, a legal pluralist system looks like. And usually it kind of like also, legal pluralism like corresponds to kind of like the diversity that you find in a country. So like in Kenya, we have a lot of ethnic diversity. I mean, we're still not the most ethnic diverse country in Africa, but we tend to believe that we are super ethnically diverse. And, we have based on who you're listening to, we have between 44 to 110 distinct ethnic and racial groups with unique cultural practices, approaches, when it comes to personhood and status, belonging and property. And then we have a lot of religious diversity, with a majority of Kenyans identifying as religious and expressing opinions that religion should play a larger role in law and policy making. So especially those two kind of like really inform a lot of kind of like what informs like the hybrid legal system that we have here in Kenya. And then we had a lot of like, when you think about colonial history, British indirect rule kind of like delegated the adjudication of certain civil law matters to what they called traditional chiefs. And so that led to a lot of references to customary law in a limited range of issues. And here I've mentioned marriage inheritance as an example. And then we had the application of Muslim law, like in what was known as the 10-mile coastal strip. And that particular legal approach has led to the establishment of Kathi's courts as a part of Kenya's judicial system, or what we call, what in other countries might be known as Muslim courts. And then we had the 2010, the constitution and the constitution making process also. There was a lot of kind of like deep divisions on the place of Kathi's courts in the Kenyan constitutional and legal system. And there was also kind of like a lot of care taken to kind of like ensure that you have that kind of respect for ethnic diversity. And that also informs kind of like how customary law is kind of like included and incorporated into Kenya's legal system. And then finally, what you had at the end is that the constitution itself came in and has provisions like on the place of customary and also Muslim law in the lives of Kenyans. And so like you'll find that, we have the typical, as Justice G was saying, we have still the repugnancy clauses, but we also do have a supremacy clause, which kind of like overrides like the application of especially customary law if it is inconsistent with the Constitution. So we have that supremacy clause in addition to a repugnancy clause, I would argue. And just to kind of like really continue, I mean, it's the same kind of like discussion over there, where you kind of like see that the Constitution provides a balance of overlapping, intersecting, and competing legal regimes. And for example, you have Article 2, Subarticle 4, which talks about any law, including customary law, that is inconsistent with this Constitution is void. And also, like, you have Article 2.5, which talks about the general rules of international law. And I would have kind of like gone into like a bit of a tangent on kind of like the limits of Article 2, Subarticle 5, because there's a bit of debate there about the place of international law. So even though sometimes we say that our Constitution draws references from a lot of other laws and constitutional approaches, we do have unique quirks which kind of like make the Kenya Constitution unique, but some of these might actually need to be resolved in a more meaningful way down the line. And so when it comes to cultures, my other co-panelists have discussed, we have the Article 10 on the national values and principles of governance. And someone had mentioned, like how can we kind of like reconcile customary law principles with the national values and principles of governance in Article 10. Perhaps in the Q&A, we could talk a bit about that as well. And we have Article 11, which is on the right to culture, which is kind of culture is recognized as the foundation of the Kenyan nation and kind of like the propellant of like what can be described as a distinct Kenyan identity or a Kenyan civilization. And that's something else that we can talk about because there's research in Kenya that suggests that Kenyans are more likely in certain instances to identify with their religion or ethnicity than they are to identify with their nationality as Kenyans. And then, so basically when you look at Article 11, which is quite limited, you'll find that there's a lot of emphasis on, you know, kind of like technology and science and cultural ownership and, you know, income generation from like cultural assets. And I think that this might have been informed by a big controversy that happened on kind of like the copywriting of certain, you could call them distinct Kenyan, you know, kind of like designs or ways of, you know, clothing, etc., very important cultural artifacts from Kenya, which have been copyrighted abroad. And that kind of like has led to a situation whereby a lot of kind of like, you know, maybe that spurred the way like, you know, Article 11 was designed. And it would have been interesting to see like a longer chapter on culture. I think, you know, like just discussing on the hypotheticals for me sounds quite exciting. And so like, I mean, legal plural, we are a very pluralistic state, yes, but at the end of the day, it is kind of like a bit hard to implement this legal system in the country. And a lot of the things that kind of like inform this, we've discussed over the course of today. And, you know, number one is the fixedness, you know, the quote-unquote fixedness of cultural identity, which is in turn tied to ethnic and religious fixedness. So that means kind of like, you know, ethnic, cultural, and religious identities cannot or should not fundamentally change, that they stay the same, and they provide for society like a bit of stability in kind of like going back and recognizing that some things haven't changed. You have a lot of patriarchal and masculinist influences, where men are recognized as the keepers of culture, especially when you think about this idea, you know, we talk about, you know, like reliance on male council of elders or male elders who are routinely called upon as witnesses in court cases to describe cultural beliefs of a community. That's kind of like one of the ways in which that patriarchal and very masculinist approach to customary law, or even kind of like the interpretation of religious texts, is in turn codified in a sense by the courts. And then we have the effect of colonialism and attempts to document customary norms in particular. Most Kenyan lawyers kind of like when they're thinking about or when they're going through their law of succession classes back in law school, they're introduced to all these like legal treatises which have risen to a point where they're kind of like sources of law in themselves. And these are kind of like anthropological and other texts, which were just kind of like describing the ethnic beliefs of a particular community, of particular communities. With this in mind, I'm thinking most of all about like a very famous book by Eugene Cottran, which kind of like documented certain customary law, certain forms of customary law in Kenya. So that's kind of like another way of like, you know, to kind of like see that, you know, that contention, like you can go all the way back to Hegel, which is like, you know, communities which rely mostly on oral histories, like do not have a civilization. That has been a very racist contention that has continued for a very long time. And so kind of like putting documents or putting cultural beliefs or oral histories or customary law down on paper is a kind of like, you know, that kind of codification legitimizes some of these practices and laws, but then at the end of the day, they kind of like freeze them in a point in time, and that has its own problems and challenges. And then also Kenya is a very cultural, religious, and politically conservative country. I think people like thinking that, you know, that they could go back 100 years ago, and they try to, you know, to think that, you know, if we went back 100 years ago, the same things that we are doing now, the same things that were happening. That is not really true, but Kenyans do, you will find that like the political leaning or slant is in that that direction. And then finally, we have a lot of rule of law problems, like impunity at all levels in government, lack of respect for laws and judicial decisions, and then lack of trust in legal and judicial processes. Legal pluralism is a very kind of like careful balance of different legal regimes. And
Kenyali, I have lost you, and I'm not sure if it is just me.
Yes, we can't hear anything.
Yes, Kenyali, we've lost your audio. And now also your video. So I know he said he was having some problems with his internet connection.
I think he's back.
Okay.
hello?
Yes, go ahead.
Oh, I'm so sorry for that. So apologies once again, just for the shaky internet. I was about to conclude, but I was just talking about like the rule of law problems that we might have in this country that make it very difficult for us to kind of like have that strong, perhaps kind of like a stronger reliance and a stronger like, tendency towards like appreciating that a legal pluralistic system is somehow good for the country, and it was set up for a particular reason. And so just to kind of like continue, I would say that at the end of the day, I mean, we have a lot of challenges when it comes to our pluralistic legal system, but I will say that, there are some good things to note about our country. Kenyans continue to negotiate multiple identities. So you'll find that Kenyans have multiple and intersecting religious, cultural, political, and demographic identities. And, they assign these identities meanings that kind of like lead to a state of social flux. And, like you approach certain social problems with that kind of like dynamism in mind. And I think that is quite inspiring. And then there's also the softening of the power of customary law, certain customary and cultural practices, which kind of like, further down the line might actually empower women in a more meaningful sense. So as someone who works for a women's rights organization, when I see the lowering incidences of harmful cultural practices, I also see the loss of power by patriarchal keepers of tradition, and then the empowerment and agency of women and girls. And so for me, it's to think, what's the next step when I see this kind of empowerment at that cultural and customary law level? And I think that one of the things that has been really interesting to me as I was thinking about this presentation was Article 17 of the Maputo Protocol, which I believe creates pathways for women's participation in the development of culture. And so like just to kind of like read out the provisions themselves, the first one is Article 17.1 of the protocol, which says...
I'm too sorry, may I suggest, because we've only got a couple of minutes before we close, if you could just summarize and close so that we could just take in a couple of comments.
Oh, yeah, definitely. Yeah, and I was just kind of like finishing by saying that, like the Article 17 of the Maputo Protocol empowers women to have the right to live in a positive cultural context and to participate at all levels in the determination of cultural policies. And, state parties shall also take appropriate measures to enhance the participation of women in the formulation of cultural policies at all levels. And when I think about this particular provision, I'm like, how can we ensure women's participation in cultural development? Perhaps something that we could do, and to also, push for that dynamism when you think about culture or when we think about customary law practices. We can, should we set up a law and culture commission, which is set up to determine and develop customary law? And that could be an avenue where we're actually giving women a larger role in kind of like pushing for that dynamism, and also kind of like trying to say, this set of laws or this set of principles should stay, or these ones like they've just kind of like, there are things in the past. Yeah. But that's the end of my presentation. Thank you so much, Mshai.
Thank you very much. And to both the panelists as well as our keynote, I think those were all just rich insights that have added to the conversation I've had this morning. I let each one of you go a little bit longer because I think I only see one question, which I will go to straight away, but I just wanted to appreciate the richness of what you have given us, the discussion on bringing in religious law. And I know there's been always this conversation of what relationship do we have between religious law and customary law. Also the idea that I think, Kanyali, you challenged us to think a little bit more about this question of national values and principles that we also heard about in the morning, on legal pluralism, and just this contentious nature that Abaka Zain also brought out. I see a question by Professor Mandosela, and I'm going to ask each one of you if you would respond to that, but also given time, just as you reflect on what we have said. I don't see any other questions. So I would ask each one of you to reflect on that, but also bring us to a place of your final comments, having listened to each one of you. Because I know that we will be going into group sessions, and I know some of the things that you have said will be fleshed out more in those group sessions. So Professor Mandosela said that, like us, Kenya has a long way to go in advancing equality and human rights through transformative constitutionalism, and wondered if we could each share perhaps one case study, just mention a case study, where we can clearly see bold, transformative constitutional moves by the Kenyan courts. I think that Justice Mumbi will probably especially give us that, but also any other initiatives that you want to bring in that we can clearly see how these are being advanced, I would be very grateful for. May I start with the keynote? And Justice Mumbi, would you like to share your thoughts on that question and make your final comments?
Thank you, Dr. Mshai. Thank you, Professor Tuli, for your question. I think we have a rich history in Kenya of trying to advance social justice for women, even before we had the new constitution. I think what it has done for us is give the courts the proper tools for making sure that our customary laws do not continue to oppress women and lead to their being denied various opportunities that they really ought to be entitled to. The question, I think the one case that I think might come close to what Professor Tuli has in mind is the one I mentioned earlier, relating to the rights of women to be involved in, to be included in adjudication of land in community, in group ranches among the Maasai community. I say it might come close to, because it's a case that hasn't been determined yet, and it's a question that hasn't yet been determined in any other, it's an issue that hasn't come up in any other case, to my knowledge, before our courts. Questions like the rights of women within marriage, what the implications of Article 45 on the equality between men and women within marriage, that question has now gone up before the Supreme Court on what precisely the implications of Article 45 of our Constitution in relation to equal rights of women in marriage as it applies to division of matrimonial property is. In relation to succession cases, one interesting aspect that has yet to be determined is a question whether a woman should still continue to be considered a unit, as we do in Section 38, I believe, in the determination of the shares of children and the widow in a monogamous union where the husband of the husband of the home, the man of the home, has died. In relation to polygamous marriages, we have 2 or 3 interesting decisions where the courts have said that the first wife in a polygamous union should have her share of the property acquired before marriage, during the marriage, determined before the property of the deceased can be subjected to the intestate, the rules of intestacy under the Law of Succession Act, as between a widow and her children, where the Law of Succession Act basically still treats a woman as a unit and therefore puts her on the same level as one of her children. That question has yet to be determined. And of course, the question of why women should only have a life interest in an intestate person's estate, while a widower doesn't have the same limitation, all of which stem from our cultural views that women are only entitled to inherit so long as they do not remarry. Again, that has yet to be considered. But I think my view of the question of how we are using, or we are likely to use the principles in the Constitution to advance social justice for women, I think is dependent a great deal on how well and how advanced in our thinking as judges, as judicial officers we are, and how committed we are to seeing that social justice is achieved for all vulnerable groups, but specifically in relation to gender. I also wanted to mention the question of domestic violence. I think one of the panelists, I think it was Nkosi Holomisa, who spoke about domestic violence and the makings of a real man in our customary culture, in our customary settings. And in Kenya, we speak a lot about certain cultures allowing men to discipline their wives. Discipline, I put it in quotes, and this being used as a justification for domestic violence and as an explanation for how men are going overboard with the domestic violence, and therefore the domestic violence at the domestic level. And again, the issue that occurred to me is this question of culture allowing violence against women in the name of discipline. Is it also one of the distortions of our culture that we have accepted as truth? And isn't it time we interrogated some of these statements that we make about our culture and the way we use them to justify acts within a domestic setting that are really not justifiable, that really amount to criminal offenses, even if we have all, both men and women, seem to find them acceptable on the basis that they are parts of culture. I think that is what I would say in closing, Dr. Mshai.
Thank you very, very much, Justice Mumbi. And I'm so pleased that you ended with a challenge to all of us, that we must really think not only about the language, but the way the stories we tell and the way we reaffirm certain ways of thinking about certain things, and to remember that we can change these and make them into something that truly serves the interests of social justice. Abu Bakaze, your final comments, and I know we're running out of time, so
yeah. So I'll be very brief. I agree with Justice Mumbi Ngugi's input, but also to give Professor an example of the first case that substantially handles the question of Article 43 of our Constitution in terms of socio-economic rights. And I will put the references in the chart, but it is called the Mitubel case, where the Supreme Court has affirmed the justiciability of the socio-economic rights for everyone, and extended the interpretation of the kind of protections that the state should consider when it involves citizens' rights. Thank you very much.
Thank you very much, Abu Bakr Zain, and really appreciated the way you have helped us to continue to flesh out, not only looking at the past, but also some of the courts, the cases that are continuing to help us to think through these cases. Kanyali Munya, I hope you're able to. Great.
Yeah, I think I'm back. Sorry. Yeah. So I just wanted, if I could mention like I think that the case that is at the High Court that Justice Ngugi mentioned, I think that would be like a pretty big game changer, because it kind of like addresses a bit of some of the issues that we are seeing, like parts of the Constitution that haven't really been fleshed out, such as Article 60. I would say that the High Court and Equality Now Act on this just ruled in our side on attempts to kind of like throw out the Prohibition of Female Genital Mutilation Act. And the High Court actually did say that there's that the government does have like the mandate of protecting women and girls and every individual from harmful cultural practices. So that would be my case of transformational constitutionalism, because we were really close. I mean, some of the arguments by the opposing side, like we're kind of like quite on the mark, and it's good that the High Court made that balance. That would be the one for me.
Thank you very much, Kanyali. And also, I just appreciate the very rich presentation that you gave us that fleshed out so much of the issues also that have been spoken to. I'm sure all the participants, I was going to read a couple of comments, but I know we've run out of time, have appreciated all three, or the keynote as well as the two panelists, for the very rich material that you've given us, and for the way that it is in such conversation with the discussions we've been having in the morning. So as I thank the Social Justice Chair for this opportunity to be part of this conversation, I believe Marna Lawrence is standing by to help us move on to the next panel. So welcome, Marna.
Thank you, Mishai. Thank you for this wonderful facilitation. Thank you for our panelists, for Justice Ngugi, for Abubakar Zain, and for Kanyali. This was really so enriching. I see that one of our panelists that had, one of our participants that was just leaving now said this was a conference that highlighted the importance of not being afraid to stay informed on issues that affect us as a people. And I think that that is a wonderful testimony to what we are achieving here today. So our next plenary is then our breakaway sessions, our 4 breakaway sessions. So just some technical advice here for those of you who registered yesterday. So those who registered yesterday would have been assigned to your breakaway rooms. So you will basically automatically go to your breakaway rooms. For late registrations, those that registered today, just follow the prompts on your screen. So once the parallel sessions will be opened now, on our end, you just follow the prompt on your screen if you have a prompt. Otherwise, you will automatically behind your breakaway rooms. If you have any problems with technical difficulties, please just post for us in the chat and we'll see what we can do to assist you. So this will then continue for an hour and a half. We've got this plenary, and then we will have a quick break after this this plenary with the breakaway sessions, a tea and coffee break, which will be 15 minutes at 16:30, after which we will then have our final plenary session at 16:45, 16:45. Thank you, everyone. We will see you in an hour and a half. Okay, colleagues, so I see that Dr. Dahlia is having trouble with joining us, so I'll then just handle our facilitation for this moment. I just want to be sure if we've got our keynote in as well. Do I see Judge Ntida? I don't think so, so just give me another one moment to just see if she's maybe gone into a colleagues, I want to welcome Dr. Dahlia, who is our facilitator for this group. We are just trying to still track our keynote, Judge Ndita, to see if we can find her. Otherwise, we're going to start with the presentations and then we will
traditional or the use of traditional courts in the determination of a number of legal concerns, one of them being divorce and succession. So when we speak about succession in traditional leadership, and you look at the framework, what are we truly speaking about when we say women deserve to have equal entitlement to leadership roles or traditional leadership roles? Does that mean that we change our conceptions around who is entitled to land and the customary principles? Because it is of no use if we understand equality in succession as equality to use and mobilize the same systems of oppression that have existed and continue to oppress and marginalize women in rural areas who are predominantly Black women. In another aspect of what does it mean, what does a succession look like, one of the issues speaking to traditional leadership roles and succession in that particular area has been the use of the concept of communal land by royal families or chieftaincies to exploit the communities over which they are
the existence of the customary marriage, even where they were present and they in fact assisted in the negotiation process. At the time that they realized that
what could amount to rental slips. So you are, effectively renting. So you don't have that security of tenure that you would have had as part of communal land security, but you are rather renting. And this creates a situation where where you fail to make your rent, it's basically land tax. Where you fail to pay that tax, then they can repossess effectively the land on which you live on. And so this introduces another dynamic around what are we speaking about when we speak about equality in questions around a succession, around in the family, but also in traditional leadership roles. What are the systems, regardless of how we understand succession, what are we calling for succession into? Are the systems that have kept women marginalized and immobilized within rural context still going to continue? Or as part and parcel of challenging the exclusion and marginalization of women within that context includes dismantling the very customary practices and systems that have continued to marginalize women within the rural context. So I'll leave it there. I see the speaker, the keynote speaker has joined us. And hopefully when we do then begin to get into the question and answer session, we can further interrogate some of the issues that I've brought forward and provide some thought and discussion around those. Thank you very much.
Thank you, Mrs. Siwe, for that rich presentation. Just a couple of house rules, which I failed to do because of time, and I just entered the room. We are going to take all the presentations, and then after that, we're going to go into discussions. And I would also like us to put up our questions on the chat, or you can also, so under the, where you see participants chat reactions, you can raise your hands for questions. So let's welcome.
It's Judge Ndita. Judge Ndita.
Yes, sorry. Let's welcome Judge Ndita. She's the judge of the Western Cape High Court. Welcome, Judge Ndita. Over to you. Is she here?
Judge, we see you in the room, but you're unmuted. Yes, there you're unmuted.
Can you hear me now?
Yes, we can.
Okay, thank you very much. I apologize. I've always been in the room. I got lost in transit, and only after Diana re-invited me that I got to be here. That is the challenges that we face with this kind of conferences. Thank you very much for inviting me this very important conference, which also happens to be closest to my heart. And thank you for inviting me. As an 8-year-old child growing up in the rural village of Nyanga, Engcobo, I watched with disbelief as my mother and her 4 daughters were evicted from their home after the death of our father, simply because she had not born a male child who would be an heir to the estate of our late father. Fast forward 30 years later, as a magistrate in KwaBaga, I was administering estates applying the rule of primogeniture. The rule has its roots in the Black Administration Act, section of 1927, section 23, which purported to give effect to customary law of succession. Central to the customary law of succession is the Primogeniture Rule, which in a nutshell prescribed that only a male who is related to the deceased qualified as intestate heir. Women did not participate in the intestate succession, and the eldest son of the family head was his heir. If a deceased person was not survived by any male descendant, his father succeeded him. If his father also did not survive him, an heir would be sought amongst his father's male descendants related to him through the male line. This exclusion of women from intestate succession, in the words of Chief Justice Pius Langa in Bear versus the Magistrate Kayelicha 2005, Volume 1, BCLR 1 CC. He said, it was in the succession was in keeping with a system that dominated by a deeply embedded patriarchy, which reserved for women a position of subservience and subordination, and in which they were regarded as perpetual minors under the tutelage of their fathers or the head of the extended families, or their husbands for that matter. In Bay, the Constitutional Court declared Section 23 of the Black Administration Act to be inconsistent with the Constitution and invalid, and more specifically, declared the rule of primogeniture as it applied in African customary law of inheritance of property to be inconsistent with the Constitution to the extent that it hindered women and extramarital children from inheriting property. It is against this background that questions of equality and succession challenges in traditional leadership and the family should be interrogated. In the summary of the judgment, it is noted that because of the issues that were to be canvassed, the Chief Justice directed the registrar of the court to deliver copies of the directions and the 2 applications before it for confirmation to the chairperson of the National House of Traditional Leaders. However, no submission were received from the House of Traditional Leaders. The rationale behind this invitation was that this approach is premised on the provisions of Section 211 of the Constitution of the Republic of South Africa to the following effect. 1, The institution, status, and role of traditional leadership according to customary law are recognized subject to the Constitution. A traditional authority that observes a system of customary law may function subject to any applicable legislation and custom, which include amendments to or repeal of that legislation or those customs. 3, the courts must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. It is so that for most women in South Africa, more specifically in rural areas, their first interaction with the law is through the traditional courts. They therefore are subject to customary law. It is therefore regrettable that the institution of traditional leadership missed the opportunity to make submissions during the hearing of the matter. However, it must be understood in the context of submissions made by the Eastern Cape House of Traditional Leaders on the customary law of succession amendment bill of 1998, wherein they argued that the laws of succession are inextricably linked with African concept of family and kinship. The report of the South African Law Commission on Customary Law, Project 90, states that the House in a written submission declared itself fundamentally opposed to the Eurocentric approach which is prevalent in our country and decried the extension of Roman Dutch law principles to customary law. Langa CJ in Bear at page 16, paragraph E to F, also notes that the codification of customary law, which in turn led to marginalization, denied it of its opportunity to grow in its own right and adapt itself to changing circumstances. The learned Chief Justice remarked as follows, and I quote, "Customary law places much store in consensus seeking and naturally provides for family and clan meetings, which offer excellent opportunities for the prevention and resolution of disputes and disagreements. Nor are these aspects useful only in the area of dispute. They provide a setting which contributes to the unity of family structures and fostering of cooperation, a sense of responsibility in and of belonging to its members, as well as the nurturing of healthy communitarian traditions such as Ubuntu. These valuable aspects of customary law more than justify its protection by the Constitution," close quote. But as I've already said, the application of customary law is subject to the Constitution. Section 6 of the Traditional Courts Bill of 2017 also provides that traditional courts are intended to promote equitable and fair resolution of certain disputes in a manner that is underpinned by the value system applicable in customary law and custom, and function in accordance with customary law subject to the Constitution. Traditional courts recognize the consensual nature of customary law, must be constituted and function under customary law and custom in a manner that promotes restorative justice, Ubuntu, coexistence, reconciliation, and in accordance with constitutional imperatives and the provisions of the Act. The issue of inheritance by women has, through judicial intervention and legislation, been settled as all estates are administered in terms of the Intestate Succession Act. But that said, law is but the means, justice the end. the question then that arises is, have the legal inroads delivered justice and equality to women who are subject to traditional leadership? Professor Madonsela says, and I agree that, I quote, "It is important that we assuming the repugnancy or delinquency of customary law and treat it as we would treat any other law. This means appreciating its redeeming features, its problem areas, and colonial distortions that exacerbated women's vulnerability and other oppressive features." I started with my address by referring to what had happened when I was 8 years old to complete the story. The institution of traditional leadership showed its redeeming features, because when my mother returned to her maiden rural village without a male figure to speak for her, the then chief of the village immediately allocated a plot for her so that she could build a home for her 4 children. This was out of step with the subservient and subordinate position of women in society of not owning land. I also remember administering an estate of a certain family in 1992 at the Kwapaca Magistrates Court. And when I advised the eldest son, who would be heir, that he would then inherit all of his late father's estate, his reaction warmed my heart. And he said, and I quote, "Manje utata usebenze eGauteng yonke iminyaka yokukhula kwami, ndikhuliswa ngumama. Kwenzeka njani ba umama kufuneke athobe kum?" Now that loosely translated reads as follows: "Magistrate, my father has been working at labor centers throughout all the years of my growing up. I was raised by my mother. How is it that she must now be subordinate to me?" The aforegoing anecdotes clearly demonstrate that the sands were shifting in the context of African customary law. But that said, rural women's first interaction with the law is at the level of traditional court. In fact, many people in South Africa are still subject to customary law. It cannot be denied that the institution of traditional leadership is entrenched in patriarchy and masculinities, which still define a woman's place in society and in the home. How do we ensure that institutions of traditional leadership uphold the constitutional values of equality and human dignity? How do we ensure that they will not use culture to discriminate against women? Although there have been progressive legislative reforms, but this will not work without vigorous education. Governmental agencies, commissions, international bodies, and non-governmental organizations all need to educate citizens on women's rights, including the right to equality within marriage. Women themselves may impede implementation of a law advancing equality if they do not understand what equality of treatment under the law means. Programs focused on raising women's consciousness about their rights, especially rural women, must be developed. Chairperson, thank you very much for the opportunity to make this presentation. I take note that this is a second conference hosted by the Law Trust Chair in social justice during 2021. The chair's mission is commendable, and I trust that the ideas espoused therein will filter through to the women in Gogolweni, Kalinyanga, and similar areas, Hanover Park, Nyanga, Manenberg, and every other area where gender, race, class, culture intersect to the disadvantage of the women of South Africa. I thank you.
Thank you very much, Judge Ndita, for this interesting presentation on the shift on the customary law, and also to remind us on how traditional leadership is still being entrenched in patriarchal system, and the need to educate women on equality. We welcome our next speaker, Dr. Munya Abu Draft. Dr. Munya is a senior law lecturer at the University of the Western Cape, Department of Criminal Justice and Procedure. He is both an admitted attorney and a sworn translator of the High Court of South Africa. He is a marriage officer for the Department of Home Affairs. He has also been appointed as a CRL Rights Commissioner by the President of South Africa to promote and protect cultural, religious, and linguistic rights. The CRL Rights Commission is a Chapter 9 institution. Dr. Munya Abu Draft has obtained an LLD law degree, an LLM law degree, and an LLB law degree, and a diploma in Arabic linguistics during his academic career. Dr. Munya, over to you. Thank you very much.
Thank you very much, Dr. Dalia. Without any further ado, I will then present my, my piece. The topic of my discussion this afternoon is an analysis of the impact of the South African Constitution on the recognition of Islamic marriages for purposes of intestate succession law. So how did the South African Constitution impact upon Islamic marriages with regard to Muslims in these Islamic marriages to inherit? Now, just a brief background, Muslims have been in South Africa for over 300 years. The population of the Muslim community in South Africa is over 750,000 in number. Now, these Muslims, or these persons, they are required in the private sphere, in terms of their religion, it is required by them to follow the Islamic law, right? So within the South African Constitution, currently, we do find there is a right to freedom of religion, there is the right to freedom of equality, there is also the right, or basically there's nothing preventing the government from enacting legislation that governs, for example, religious marriages. Now, prior to 1993, prior to the Constitution of South Africa, the state of affairs was not very welcoming as far as these Islamic marriages or marriages concluded in terms of Islamic law is concerned. In 1917, in the case of Sidart's executors versus the Master of the High Court, the then appellate division held that foreign polygamous marriages are not to be recognized. So the issue here was concerning the allowance or the permissibility of a man having the right to marry more than one wife. So that was the issue. In 1983, in the case of Ismail versus Ismail, the appellate division confirmed the position and held that a marriage under which polygamy is allowed is regarded contra bona mores. And it stated that under South African law should accordingly not be recognized. Now, the judgment referred to polygamy, which is basically the general term that could either be polygyny or polyandry. Now, polygyny would be where the husband has more than one wife, which is allowed in terms of Islamic law, and polyandry is where a wife has more than one husband. And we have heard the discussion around this in the green paper that was published by the Department of Home Affairs not so long ago. Now, subsequent to 1993, when the interim Constitution of South Africa was enacted, it then allowed for the right, or it provided in the Bill of Rights, in both the interim as well as the final Constitution of 1996, the right to equality, the right to freedom of religion, the right not to be discriminated or unfairly discriminated against. So the status of the Islamic marriages subsequent to the constitutions of South Africa then had to change, because the Marriage Act, right, allowed for couples as well as Muslims to marry in terms of the act, and their marriage would be recognized. However, the consequences of that marriage is not necessarily in terms of Islamic law. So many South African Muslims then took the option of not concluding those marriages. But the consequence to that would then be that their marriages would not be recognized. Now, in 1993, an issue then arose in terms of the recognition of this Islamic marriage for purposes of succession. So the husband passed away, or the man passed away. He was married to his wife in terms of Islamic law. However, when he passed away, he died without executing a valid will. So the issue was whether or not the lady who he was married to was regarded as a spouse for purposes of the Interstate Succession Act 81 of 1987. In the case of Daniels versus Canberra, in the then Cape High Court and now the Western Cape Division of the High Court, where the Honourable Judge has this, where she resides, it stated there that it found that the provision is unconstitutional, as it does not recognize a spouse married in a monogamous Muslim marriage or Islamic marriage. The matter was taken to the Constitutional Court for confirmation, and it was confirmed with the effect of recognizing a spouse, a surviving spouse, in terms of a monogamous Islamic marriage. But at that time, it did not recognize a polygynous marriage. Now, in the next case, in 2009, in the Hassan versus Jacobs Constitutional Court judgment, it also started in the Western Cape Division of the High Court, and it ended up in the Constitutional Court. And the argument was again then made that not allowing these surviving spouses married in terms of Islamic law to inherit, it infringed on their right to equality, the right to human dignity, the right not to be discriminated against, and so forth and so forth. So the South African Constitution has impacted upon their rights as citizens of this country in order to claim inheritance from a deceased person, and that is now the spouse, in the event where he or she passes away intestate or without a will. Now, this does seem to be a move in the right direction, definitely so, because non-recognition of the marriage would deem that the widow or the widower would be entitled to nothing. However, the problem with the scenario at hand is that the distribution of the estate is not necessarily in terms of Islamic law of succession. Now, in terms of the primary sources of Islamic law, in the Quran, in chapter 4, verse 11 and 12 specifically, it refers to how the estate should be distributed. Now, the Interstate Succession Act 81 of 1987 does not necessarily coincide with what is stated over there. A possible solution to this could be the enactment of legislation, also in terms of the South African Constitution, more specifically Section 15(3) of the Constitution, which says that there's nothing preventing the Parliament and government from enacting legislation that governs religious marriages or customary marriages and so forth. So that would be on a constitutional basis. A testator, however, could also make use of the right to freedom of testation in order to enact or give effect to his or her private, basically the private sphere, the religious requirements, and draft that in a duly drafted and executed will. Right. However, in the absence of that, it would unfortunately lead to a situation where the distribution would not, however, be in terms of religious premise. There is, however, nothing that prevents a party by way of a gift, as well as in Islamic law, to distribute the estate accordingly, and that is also allowed in terms of South African law. Right, so yeah, that is my 7 minutes, and that is an overall overview concerning how the Constitution of South Africa has impacted upon Islamic marriages as far as the laws of intestate succession is concerned. I thank you.
Thank you, Dr. Munya, for this insightful presentation on the impact of the Constitution on Islamic marriage. And the more I listen to your presentation, I see that we are going to have a lot of conversation on this topic, especially on when we are dealing with religious laws, or maybe when we are looking, I call it maybe personal laws here. And then when we are looking at the Constitution. So I think our audience, we are having, we are getting ready for our questions. Let's welcome Letabo. Sorry if I mispronounced the name, Lobatla. I hope I'm correct. Letabo is a seasoned business management practitioner and entrepreneur with over 15 years of industry experience. His commitment to development has led to a great interest in governance and ethics, given the current affairs of leadership challenges in our country. He's passionate about contribution to the corpus of knowledge on the issues of human rights, corporate governance, strategy, and ethics. He's currently completing his qualification towards the certified director designation with the Institute of Directors of South Africa. Over to you, Letabo. Thank you.
Thanks a lot, Dr. Diala. I hope I've pronounced your name correctly.
Yes, you did. Thank you.
Okay, I will share my screen if that's all right.
Go ahead.
Thank you so much. My discussion is going to be based on the cultural influences and practices of inequality in customary law, succession, and inheritance in South Africa. Basically, what I was looking at, as we know that the issue is settled in Ben Others versus Magistrate of Khayelitsha and Shilobana and Others versus Mamitwa, that the discrimination on the grounds of gender was declared unconstitutional. But however, I have found or detected that there are other nuances of inequality practiced within the customary law of succession. In particular, I think we will be looking at the interstate law of succession. Obviously, the testate law of succession is protected by the freedom of testation by the testator. So I will not be touching on that because that is an issue for the courts. So the male primogeniture, I've heard Judge Ndita, and I think Commissioner Deyi also spoke to it. It is continuing in practice despite the decisions that came from the two cases that I've mentioned, where in the African family structure, you will find this patriarchal and hierarchical structure, which are premised on inequality. And then one view that I held, especially when you look at the structure in the families, the seniority in the family is given based on the houses, which obviously looks at the birth of the eldest male boy, the eldest son or the male in the family, who will obviously inherit the family property, and also in the law of succession to become the family head. And that in itself, you will already see the nuances I'm speaking of inequality, in that the younger children will be overlooked. They are not looked at the same level, at the same lens. You know, they are denied equality and dignity based on their chronological way of being born in the family. In the Pedi culture, we've had another very, very different perspective in a principle called Mojalefa ke moletantlo, meaning the last born in the family actually has to inherit the family property. And in that itself, although it's like now looking vice versa, but it's still putting the siblings in an unequal position, and obviously denying equality, as I've already mentioned. So I have identified several challenges that go with this practice, and that obviously need reform. One of which I have looked at the economical impact of the practice, the male primogeniture. The practice fails to recognize that even though by birth you may be senior in the family structure, however, you may not possess the skills and capabilities to lead the family, or even lead the family-owned businesses. So, which is the reason, in fact, if you look at it, you look at what was happening in the townships pre-94, or maybe even in the 90s as a whole, you will see that we had a lot of successful Black entrepreneurs who owned spaza shops. And at the time, you know, the family, the person who actually started the business would take it and grow it. But when the person passes, when the business is supposed to be passed over to the heir, there comes issues, because as I already said, the heir apparent, you may find that sometimes is not really qualified, skilled, and will also not look at the interest of the family. And then I'm going to continue again on the economical impact. And then this practice obviously has led to disputes in the family, because you may find that the younger siblings, male siblings in the family, they are reduced to be subservient to the heir apparent, the eldest male member. And then they serve him. And obviously selfish interest, or self-interest, as we know it is inherent in all human beings, often leads the family to have disputes where one will feel they are serving the other. And this has led to bigger challenges, of course, other consequences involving poverty, where the family business will fall to its knees due to poor leadership or lack of strategy and competitive strategies. And then it will lead into inequality, separate development in the family, diminished family ties, because the younger siblings will feel we don't need to invest in the family business, because either way, we're not going to inherit. So they seek out independence and leadership and dignity away from the family. And obviously this is a disservice to the family itself, because the families will no longer be closer to each other, which obviously we understand that is in the spirit of Ubuntu. I'm going to continue. Here I have put together a picture for you to see what I'm speaking of. If you look at this, I'm sure, I listened to Judge Ndita as she started her presentation. She was speaking about growing up in the township, the rural areas. I think we all remember this type of shop. We had them in the 90s and they were doing well. And you can see now they looked derelict. And then that is due to various issues, one of which, the main contributor, it is the succession problem that is based on the male primogeniture of the eldest born son, whom sometimes don't have interest themselves. And they are sort of like the duty to continue the family legacy is imposed on the eldest male born, which is the result of what we are seeing. And given what our country is going through economically with the issues of jobs, this is honestly a disservice to the development of Black communities. And then in the next slide, I have put together for you where you can now see that these opportunities are seized by the Pakistanis and Somalians. So when I do go home sometimes and I drive by, I am so depressed to see that all of the shops that I knew, of which I believe the owners of the shop, they saw me as a child of the community. Now I see the Pakistanis, I see the Somalians. And obviously this is detrimental to economic growth, especially local economic growth, which I believe that the customary law of succession needs to be amended in order to enable families to continue with the family-owned businesses and to take them to the next level. I'm going to continue. I'm going to speak now of the psychological and the social impact of the male primogeniture in the law of succession. The practice, unfortunately, it divides the family. It leads that insider, outsider principles, and family members become enemies. And then it leads to sibling feuding. And some of the situations I have seen and read from literature, I've seen that sabotage now becomes the order of the day in the family, where the elders who are aggrieved and feel betrayed by the family sabotage the business to the detriment of the whole family. And obviously, in the customary law of succession, the status is afforded due to the seniority of birth and age. So not only is the inequality just based on the birth, it's actually the age where the younger siblings, their voice is actually marginalized in conversations, where they are subdued or oppressed by the senior members, because only senior members have got to have the power to make decisions that bind the whole family, but whilst not giving effect to the voice of all members of the family. But obviously, since it's patriarchal and hierarchical, then equality becomes impossible. And I'm going to now enter into the Bill of Rights. It is apparent that from conversation that the violation of Section 9 is apparent. And then Section 10 also, I find that the dignity of the lower ranked family members is infringed, in that they are treated as peripheral to the system, to the structure in the family. Merely they are there to support, not necessarily to voice their dissent or any negation on their part. So for me, I feel that this is a disservice to nation building, family building. And I think the law of succession needs to really be reviewed in this regard. And then some of the practices are defended with some reasoning that may appear altruistic, but I'm of a different view, because we know that African spirituality has to do with ancestors, and the lineages were decided by ancestors and they will continue. So many lower ranked family members generally end up accepting this position and their subordination in their families. Yeah, I think I've just addressed this. And also I think Section 15, that the lower ranked family members, they really do not have a voice, which is the reason why it makes sense for them to migrate and to become CEOs elsewhere, away from the families. I'm gonna come to Ubuntu. Ubuntu has various definitions and there is no consensus on its objective meaning. But however, for the purposes of my discussion, I will work with former Justice Mokhoro's definition. She says Ubuntu is perceived as central to Africanness. It is a concept that is understood by Africans. It is regarded as a notion and belief born from African culture to express compassion, reciprocity, dignity, harmony, humanity in the interest of the community. Obviously, I already said that we will be looking at the interstate, because interstate is a different issue altogether. The reason I brought Ubuntu, there is a paper very compelling written by Dr. Kivi at the University of Free State around the hidden practices and oppressive practices of Ubuntu. Even though the Constitutional Court ruled discrimination on the grounds of gender unconstitutional in the customary interstate law of succession, however, they found Ubuntu to not be discriminative. It is this reason that I've decided to enter Ubuntu into the foray, because it is assumed that it is a fair process. It is, most of the time when we speak of Ubuntu, we speak about it in a positive manner, but there are the hidden negatives, the hidden oppression in Ubuntu due to the hierarchical structures in the family. And it is of my view that Section 2 and Section 5 of the Reform of Customary Law, Succession and Regulation of Related Matters, Act 11 of 2009 needs to be reviewed. I think that is the end of my discussion. Thank you, Dr. Diala.
Thank you very much for your presentation. So the floor is open now for discussion. So if you have any question, as I said earlier, you can raise your hands. So you see the reaction button, or you can post your question on the chat room. So I will open up with questions. So my question is directed to you, Letabo.
Yes.
Yes. So when you talked about that customary law fails to recognize the nuances involving the ability and capability. So my question would be, what's your definition of this ability and capability when we are talking of equality? I'm not sure if the question is clear enough. So if we begin to gauge people's ability, so what do you mean by ability? So I see you raise this point under economical impact. So when we are talking about the ability and capability, is it based on the economic aspect of it, or is there any other meaning to this ability and capability? Because for me, I feel ability could mean any other thing apart from, so economic will now mean having the financial capability, right? And then we are discussing also about equality. So tell me, so just briefly, just explain what this ability and capability means in terms of equality. Thank you. I'm not sure if the question is clear enough for you.
Yes, it is, Dr. Diala. I hope I've understood it correctly, but if my answer is not giving you the answer you're looking for, then we can try again. What I mean by ability and capability, we know that there are skills of leadership, and there are also skills that you need to acquire, hard skills, like having your degree in marketing or having marketing skills, business management skills, accountancy skills. And you find sometimes in the interstate law of succession, property devolves on someone who possesses none of these skills in order to take the family business forward. So that is my meaning of abilities and capabilities.
Oh, okay, thank you very much. The floor is open.
You can unshare. I've been trying to unshare myself here. Maybe you can override me. Okay, so no.
Did it work?
I believe I'm still under the sharing mode.
Since I'm not the host, Diane, can you help us with that?
Colleagues, it's Marna here. So we are sharing it from our side.
Okay.
Yeah, I think that's done. Jane, I just want to remind our colleagues as well, if you could maybe just procure one of the panelists to then provide the feedback on your behalf in that 4:45 to 5:15 session. It's just a 5-minute feedback that we want to provide from the breakaway sessions. If you could just maybe ask one of the panelists, we'll appreciate it. Thank you.
Okay, thank you, Mana. The floor is still open for questions, please. It's time for discussions.
If I may come in?
Yes, please.
I have a question for Commissioner Day, but I don't see her anymore. I don't see her anymore, actually.
Colleague, she had to leave, unfortunately, due to load shedding.
Okay. Maybe then the question, I don't know, should I still pose it? Because it's actually directed to the CGE.
Mana, how do we go about this?
I think you can, if you still pose it, I can see if I can get a hold of her. I'll email it to her, see if she can answer it to us. Otherwise, I will pose it to her nevertheless and send the answer to the panelists. But maybe this is something that I don't know if it's something that could be addressed by one of our, or to maybe get the opinion of one of our other panelists.
Okay, no, that's fine. You know, I listened to Commissioner Day as she was speaking during her time of presentation. And I have a question to the CGE, because when we speak of the rights of women to equality, especially in the law of succession and in every other sphere of life, whether it's in the workplace, whether it's, you know, in any legislation, in any sphere of government or sphere of business. But my view is that there is a conflation of gender and sex, because the Commission of Gender Equality is perceiving gender as sex, because sex is male and females, whilst gender, we're now speaking of the LGBTIQ+. And also, I wanted to understand what would be their view, I listened to Judge Ndita's presentation. She spoke more about women, but now we are having gender fluidity. There are men who have transgendered into women, which now leads the area gray, while we're still trying to advocate and fight and vindicate the rights of the marginalized women who are born that way by birth. But there are now other women who also deserve to be protected under the law, under Section 9 of our Constitution. So my view is that with these new nuances that are entering into their foray, how is the CGE reconciling these two issues? Because it brings another dimension in my view.
Thank you for that, Letabo. I'll definitely pose that to, I'll see if I can get hold of her via email. I think the issue had to do with data though, but maybe Judge Ndita, I don't know if you maybe have any view in this regard, how you would approach the issue.
All right. I think that it really need not be women or any particular definition, but it is just vulnerable groups, because when you talk about vulnerable groups, you include each and every person, including the gay and lesbian groups and all that. So I don't think that it need be a question of women, but it's just a question of vulnerable groups, those people who are vulnerable in society. I don't know if it answers your question, because it was really more for the CGE and how they approach it, but I would approach it as simply vulnerable groups.
I think I hear what Judge Ndita is saying, but however, I think there are still lines of gray, particularly because we had the CGE at Tekis, where we had another conference, and I still heard the same narrative, the same rationale being applied in those conversations, that sex, it is now conflated with gender. And in my view, we need to separate the two because they do not speak to the same thing. But however, when they are discussed, they are the same thing. I think one person was speaking of, I remember there was a case, we're speaking of a situation which involved a woman who was looking for a job, if I'm not wrong, and they said they preferred a woman, but once they found that this man was in the process of changing into becoming a woman, and he now used the assigned sex which he's going to as his sex, that obviously led to this man getting a job, and then a woman who was born that way by nature did not actually get that job. I just wanted those nuances, because it's a bit gray, and we are conflating the two issues. Because in my view, Judge Ndita's answer, it sort of like breaks it more, because when she says vulnerable members, I can sort of agree to that, and then maybe you just say below vulnerable members, which will be Black women, white women, LGBTI members, since they are marginalized. That will make more sense. But when you say women, it becomes a bit of a gray area, because then the person say will prefer the gender or the sex, the gender of, but while they actually mean sex. That's just my view.
Thank you, Judge Ndita, and thank you, Letabo. Do we have any reaction from any of the panelists can also ask question, and audience? Any question? Okay. Letabo, Judge Ndita, do you have any last comment for us? I think maybe questions will come up as you give your comment. So any reflections as we go on? Thank you.
Thank you. I do.
Right.
You know, as we move forward as a nation, it seems to me that our steps are quick and yet our steps are very slow, because we are not lifting the rest of the women, and let me say, for Letabo's sake, of the rest of the vulnerable groups. It is very important that women should be spoken to so that they can be conscientized to their own rights. And I was hoping that perhaps something will, from these discussions, something will come up that will put in place a way of reaching out to those women who we have left on the sidelines. So there really are no rights to equality and dignity if the people for whom they were designed are unable to access them. And we can see that those who can access them are those who have, and those who have not, do not know how to access them. So I'm hoping that this conference will then move forward towards reaching out and making sure that at the very least, they know who they are, because it's the consciousness. The rights can only be effected because of the fact that people are conscious of their own rights. Thank you.
Thank you, Judge Ndita. Dr. Munya, any final comment?
Yes, thank you, Dr. Tiana. Yes, with regard to my presentation, and also the issue concerning the Constitution and its application, with regard to inheritance challenges, traditional leadership, and the family, it seems to be that, it is that the Constitution plays a very important role and has a very big impact upon the rights of these communities. Even if you look at the bare judgment that was brought up in many of the various presentations, it shows that the lived realities is quite different to what what was the original reasoning behind the custom or the rule. Like, for example, the rule of primogeniture. And I therefore do believe that there must be more further discussions regarding these matters, and these type of conferences is definitely a good move towards the right direction. Thank you.
Thank you, Dr. Munya. Letabo?
Thank you, Dr. Diala. I think I share the same sentiments with Dr. Munya, that these debates or conversations are necessary for constitutional development and to give effect to the right to Section 9 and Section 10 of our Constitution. Because obviously, when you look at the values of Ubuntu, which are encapsulated within our Constitution, they speak to fairness, they speak to inclusion, they speak to reciprocity, humaneness. I believe that this discourse is necessary, and I was glad and honored to be part of you today. Thank you.
Thank you, Letabo. Mana?
Thanks, Jane. I couldn't find my hand. I just want to add to what our participant said. And I think it's very important if we look at court cases, also like the recent Mshlangu case where domestic workers was also brought into the protection of CAIDA, or in any case where that they have to now be brought into this protection. I think it's important for us to realize, though, that the courts are successful in making these progressive, transformative decisions, like Judge Ndita also said. But how do we then effect real change on the ground? And I think this was some of the questions or the comments that also came from the NGOs that assisted and that joined as a Mickey is, what do we do now? Now that we do have these decisions, how do we get this message through to all excluded groups, not just to women, and that these are their rights? So I think we need to do much more in terms of activism and to basically have the implementation of these laws effected on the ground, so that there's not this disjuncture between policies and implementation. So that is just a remark that I want to make to reinforce what our panelists had said.
Thank you, Mana, and I quite agree with you because I feel the work is mostly how do we meet the people on ground, especially when we advocate for all this. We advocate for a bottom-up approach. And so how do we meet these people that are the grassroots level? So how do we do that? Because I gathered from what all the panelists are saying, from Judge Ndita when she said that we need to raise consciousness, how we need to educate women on equality. And she raised issues of how is mostly the rural women, how do we go there? And then we listened to Letabo, her final comment. How do we also meet them? And also Dr. Munya. I think almost all the three panelists, they just have one thing to say, and that is this, that we need to educate people on ground. We need to raise awareness. And I think the conference is a starting point for that. Thank you, our panelists, and thank you, audience. Since we don't have any questions.
Jane, can I then just ask which one of our panelists, will Letabo maybe venture, or Dr. Munya, or even if Judge Ndita to provide us with the feedback, the 5-minute feedback in our 4:45 session? Do I have a volunteer?
I've asked Letabo and she has not gotten back to me.
Dr. Diala, it's fine. I'll give the feedback.
All right. Thank you very much.
Thank you so much, Letabo. It's much appreciated.
Sorry, before we go, may I speak to Dr. Munya quickly, just to get the pointers from him before I misrepresent him in the feedback session?
Yes, please.
Because Commissioner Day, I got what she was saying, but Dr. Munya's presentation, I just need to be more clear about what he said.
Okay. Do you need him to send it to you?
I can email it to you.
Sorry, Doctor?
Do you want me to email you the document?
Yes, please. That will help.
Okay.
Yeah, what is your email address?
SL, everybody will now know it. SL.
Yeah. Yeah.
I think you see several Tlobatlas in this room.
Okay, I can see your surname. I can see, so SLTLOUBATLA, that one.
Yes, that's the one. sltlobatla@gmail.com.
All right, I'll send it now.
Thanks a lot, Doctor.
Yeah, thanks.
Thanks so much. We really appreciate that you are stepping in for Dr. Diala. Dr. Diala, thank you as well for stepping in at the last minute for us to facilitate when our previous facilitator fell ill. I really appreciate it, as I was running around between the breakaways trying to keep up. So thank you for that.
Thank you, Mana.
Thank you, colleagues. So we will then reconvene. So it's our quick 15-minute tea break, and we will reconvene at 4:45. Thank you also in particular, Judge Dita, for making time in your busy schedule to everyone. It was really a wonderful presentation and so insightful. And I will try to, I will get you in any case in contact as well with Commissioner Day. I will provide you with an email address, and then you can maybe also pose your question to her directly.
Thanks a lot, Marna. Will do.
Okay, thank you, everybody.
Bye-bye.
Bye-bye. Bye-bye.
Bye-bye.